12 South African National Defence Force members accused of the murder of the Hawks investigator Frans Mathipa have now been granted bail of 10,000 rand each with strict conditions. The suspects appeared briefly in the Randburg Magistrate's Court this morning. They face multiple charges. They include 3 counts of murder, kidnapping and the obstruction of justice. Newzroom Afrika's Nqobile Madlala is on the story, joins us now. Nqobile, good morning to you. What happened in court?
Well, Stephen, the magistrate's just explaining that the evidence that has been brought forward is what she called frail, and that the state failed to show the role of the applicants with respect to applicant 1 to 9. But further than that, she spoke of how this probably would be able to be shown during trial. However, at this case, under the circumstances and what was brought before court, that none of the evidence could sort of pin down that these applicants were people that could perhaps evade court if they provided bail, that they could leave. And they spoke about the fact that even their passports were handed over, and also the element of the fact that you'll remember that 2 people were arrested and 10 others did hand themselves over. So that became part of what court was speaking about, and they said that they did in fact go to the police, and that in itself shows that they were willing to work with the police. He also, the court talking about the fact that in terms of Mathipa murder, even though they consider this murder very brutal, and it is in fact an agreement that the perpetrators must be brought to justice, it is, however, there's no firearm that was found. There's no evidence that the applicants that are before court had access to the gun, and that probably will have to be shown during trial. But at this stage, none of it had been shown. And I want to bring in the attorneys now that, in a sense, have brought victory to the 12 SANDF. I mean, it's a bitter pill, really, because for those that have lost Mathipa, it means that they have to start again and get more investigation in terms of who is responsible. But today, your applicants get bail.
That's correct. They get bail. I just want to point out the purpose of bail is not to determine the guilt of any of the accused today in court. The purpose of bail is to look at the interest of justice, and for Schedule 6 bail applications like today, which is serious bail applications, to prove if there was exceptional circumstances. And unfortunately, we were in the fortunate position to discharge the onus of proof, and as such, the bail was granted on behalf of all of the accused on the said date.
And I suppose it then would be a question of whether or not you believe that the people that you're representing are responsible.
For what? Sorry,
for what has been brought towards court with regards to Mathipa's passing.
At this stage, there's no indication of who's responsible for anything at this stage, and that's why we are going to a trial court where proper evidence will be led, and for the court then to make a ruling in respect thereof.
And I understand that you're back in court on the 17th of July?
That is correct. So, from the bar, as the state raised it, they are appealing the decision to grant bail by this court. So the hearing would be about leave to appeal the decision of the magistrate to grant bail for all the accused.
And of course, we understand that these are people that were working within the SANDF. One would think that outside there, people have faith with the SANDF, and allegations like this can be really damning.
They are really damning. It's about the reputation of the country, which in this context, given also the members who are being accused, it's about national interest. National interest consequentially would include even national security, of which the military is the last line of defense. So no doubt about it that it's damning. It's about the reputational risk of the country, given the seriousness of the charges. But however, as my colleague has explained, the threshold that, or the onus that must be discharged is whether there are interests of justice and whether the exceptional circumstances exist which entitles the court to release the applicants or the accused on bail. So With regard to that, if you allow me, I just want us to educate ourselves of something. The court has mentioned, or even the state, non-cooperation, which will deal with it in a trial. It's an inconsistency that we picked up as we were taking notes. You will remember our lead counsel had presented to court that there has been cooperation at all levels. The other important thing that he raised was about the warrant, which contained the theft of motor vehicle, kidnapping, and obstruction of justice. The issues relating to murder were an afterthought. If you look at the history of the matter and other issues which are involved in the matter, are that the issues relating to Section 205, Sapuna, which the court is talking about, it's not like it has not been complied with, it is being challenged. I will just allude to the Military Disciplinary Supplementary Measures Act. Section 3, subsection 3, it talks about offenses that can be investigated and prosecuted in the military courts, which is the case here. First, it should be the members of the South African National Defence Force. The second issue are exclusions. Exclusions are murder, culpable homicide, treason, and rape. Yes, there are charges of murder. However, in my earlier submission, we have stated that it's an afterthought. So there are issues relating to the arrest without a warrant in respect of things which are challenged in the High Court, and also the murder case or charges which were added as an afterthought. So there are a number of issues which are actually bordering on the line of unlawful arrest and all those things which we will deal with at an appropriate time. But at this stage, bail has been granted because the onus has been discharged. We'll hear on the 17th what the state says in respect of their grounds of appeal.
And just before I let you go, one of your applicants is said to have been, his vehicle was found with a burner phone, where they say, or it's alleged that it was used to lure Mr. Mathipa, and he would later pass away. Is this part of the conversation or the what you're going to be bringing forward on the trial?
It relates to the merits of the case, and there's so much that the accused or applicants in the bail proceedings are not entitled to. As we speak, we do not know the contents of the police docket. However, it was clear that the evidence is circumstantial, and there's also a threshold how you treat circumstantial evidence, of which you must exclude any other inferences which are drawn out of the circumstantial evidence. We're not saying that the courts can't convict, here in the matter in a trial. However, we're not aware, we do not know is the state's case during bail proceedings that are the facts that they have in the docket. But we do not know what they have. We do not know about the Benaphones. The accused instructions are that they will plead not guilty to the charges should the matter end up in trial. So we are at that stage whereby we do not know what the state has in the docket, and we can only rely on what the affidavit is saying and respond to that accordingly.
Thank you very much for speaking to us. Well, as you can hear there from their attorneys, they're saying that they're looking forward to the 17th of July. This is when the state is going to be appealing the bail that they have been provided to the 12 people, SANDF officials that now get to go home. But they're saying that they feel that they have been, in a way, working with the state, even though it has been said in court that they have not been cooperating. But certainly something to keep watching, Stephen.